District of Ohio, Judge John Chun nominated to the Western District of Washington, Charles Fleming nominated to the Northern District of Ohio, and Judge David Ruiz also nominated to the Northern District of Ohio. Welcome to all of you and your family and friends. In just a minute, we'll hear from several of our colleagues who are here to formally introduce the nominees. Before we turn to our colleagues, I want to briefly comment on a significant announcement that took place earlier this week. On Monday, our colleague, Senator Leahy, announced that he will retire at the end of his term. From day one, back in 1975, Senator Leahy has been a defender of human rights, a champion of the environment, and a fierce advocate of protecting our nation's tradition of welcoming immigrants. I'm proud to call him a colleague and a friend. We all wish him well on his retirement, though thankfully we will have him here in the Senate for another year. And of course, Chairman Leahy is a huge presence on this committee. I'd like to ask Ranking Member Grassley for any opening remarks you may have.
I have just 1 minute dealing with this hearing that we're having today, but I'd like to take about 1.5 minutes to discuss another issue that this committee ought to be concerned about. This is in regard to a whistleblower making a decision yesterday. I want to point out that yesterday we all learned about a very disturbing development at the FBI. A whistleblower there disclosed a directive from FBI Criminal Investigative Division and its Counterterrorism Division, creating a whole new threat tag about school boards and school officials that effectively targets concerned parents. That directive came out on October the 20th. Just a week later, the Attorney General Garland testified to this committee that his recent instructions to the FBI to get involved in local school board matters was not about targeting parents as domestic terrorists. But we now see that the FBI's Counterterrorism Division is focused on school board matters. So Attorney General Garland needs to come back and explain to us and the American people whether he misled us or that he doesn't know what's going on in his own department. In regard to today's hearing, these 4 judicial nominees today for the Western District of Washington and 3 for the Northern District of Ohio are very important positions that need to be filled. We have a longtime federal prosecutor, a longtime federal public defender, and 2 judges here today. And I hope that these nominations will be willing and able to answer questions from this committee. So unfortunately, like you've heard from so many of the Republican members of this committee, we've seen a number of nominees who can't or won't answer questions that would have been answered by nominees of other administrations, and I hope today's conversation can be very productive. To all the 4 nominees, I welcome you to your position and congratulate you. Thank you.
Thank you, Ranking Member Grassley. We've been joined by Chairman Durbin. Would you like to say a few remarks?
Very briefly, I'd like to make 2 points, if I might. The first is the President signed the infrastructure bill this week and made a big show of the fact that it is truly a bipartisan undertaking. Democrats and Republicans wrote the bill. The President signed it into law. It's going to do good things for America. And many of the Republican senators who were active in that were singled out for their participation, including Rob Portman, our colleague from Ohio and Senator Brown's colleague. The good news this morning is that of the nominees coming before us, both Senator Brown and Portman have reached an agreement in terms of who those nominees will be, a bipartisan agreement, which we strongly encourage. Because of the blue slip, any senator from the state that is district court vacancies being filled has the right to approve or disapprove the nominee. In this case, we have bipartisan agreement on moving forward. Secondly, on this issue of schools and safety in school board meetings and such, We have cases in Illinois where people have gotten out of hand and attacked teachers and board members and threatened their lives. This is serious business. We are all, I hope, opposed to violence and violent conduct and violent threats. That's what the Department of Justice is focusing on. And to say that this is just a matter of suppressing free speech ignores the obvious. People are showing more anger on airplanes and at school board meetings than we have ever seen, and this is a reality. I don't know about your state, but in my state, school board members aren't paid. This is a volunteer activity, and for them to have their families threatened is unforgivable, and we shouldn't be mincing words about that. So I'll join with Senator Grassley saying let's get to the bottom of what the FBI is doing, but I hope we all start with the premise that violence is never acceptable in the name of the Constitution.
Thank you, Chair Durbin. I share your sentiments regarding the totally unacceptable and illegal to threaten violence on anyone. In particular, I would say at a time like this when we're trying to get our students back in school safely against school board members. We have a number of our colleagues who are joining us this morning to formally introduce the nominees. I'll start with Senator Brown, who will be introducing the 3 Northern District of Ohio nominees. Senator Brown.
Thank you, Madam Chair, and Ranking Member Grassley, and Chairman Durbin. Thank you for your comments about violence and the leadership that all 3 of you show. It's my honor today to introduce 3 highly qualified nominees to serve in the Northern District of Ohio. Each of these nominees brings with him not only impressive legal credentials, but also life experiences, empathy, and a deep commitment to justice. It's why Senator Portman and I, who have worked together on judicial nominees for some years, both recommended these nominees to President Biden to serve our state. Bridget Brennan is the current acting U.S. Attorney in the Northern District, an office in which she has served in for over a decade. During her time as a U.S. Attorney, Ms. Brennan has taken on complex and difficult cases. She played a lead role as the prosecutor who took down multiple sex trafficking operations, including serving as the lead prosecutor of the largest juvenile sex trafficking case in the history of the Northern District of Ohio, a horrific case that included victims as young as 12. She also achieved the country's first conviction for a sex trafficker's use of heroin to control his victims, convincing the court to recognize heroin withdrawal as, quote, a threat of serious bodily harm, unquote, for the purposes of proving coercion. A champion for religious liberty, Ms. Brennan successfully prosecuted 16 defendants in a single case under hate crime statutes for their role in religiously motivated assaults after they viciously attacked members of Ohio's longtime Amish community. She successfully prosecuted a man for arson and the destruction of religious property after he drove hours just to set fire to a mosque in northern Ohio. Ms. Brennan, she received glowing recommendations from those she's worked with and those whom she's worked against. In fact, people that she has placed in jail write to her seeking advice and guidance. Clearly, this is someone whose commitment to justice is obvious to all those who deal with her. Mr. Charles Fleming, an assistant public defender in the Northern District of Ohio, serves as a trial team leader in the district's largest public defender branch. A career public servant, Mr. Fleming has extensive trial experience in federal court, serving as a federal public defender for 30 years. He's received uniformly enthusiastic reviews from judges whom he has appeared before, and from those he's tried cases against. As a lead public defender, Mr. Fleming often takes on what his supervisor described as, quote, the most difficult and challenging cases to which our office is appointed. In all his cases, Mr. Fleming has displayed exceptional empathy towards not only his clients, but also the victims of crime. I think of a story about Mr. Fleming. A person he represented was convicted of a brutal crime. According to the judge who sat on the case, when making his arguments for what he believed was a fair sentence for his client, Mr. Fleming turned and faced the victim and her family. The judge said that Mr. Fleming didn't alter his arguments. He just wanted to accord the victim and her family the dignity of hearing directly from him. His client did the same while making remarks, something the judge surmised would not have happened but for Mr. Fleming's urging. It's the kind of temperament we need on the federal bench. Judge David Ruiz has served as a magistrate judge in the Northern District for 5 years. For being a magistrate, Judge Ruiz served for 16 years as an assistant U.S. attorney in the Northern District and as a private practitioner. The breadth and depth of Judge Ruiz's legal experience is extensive. As an AUSA and in private practice, he took on a wide spectrum of cases. Those he worked with praised his temperament and intellect, describing him as unflappable. However, perhaps his most powerful endorsement was that of the judges already seated in the Northern District, who selected him to serve as one of their magistrates. They selected Judge Ruiz to oversee groundbreaking multi-million-dollar, multi-district litigation against opioid manufacturers and distributors that have devastated families and communities across Ohio, issues that Senator Portman and I have worked together on. Finally, Judge Ruiz is poised to make history as the first Hispanic district court judge to sit in the Northern District. A descendant of migrant farm workers who work picking fruit in the fields of Texas and Michigan to provide a better life for their family. His success represents the fulfillment of their wildest dreams and the embodiment of the American dream. Dr. King, as we know, said that the arc of the moral universe bends towards justice. He also said in his letter from the Birmingham jail that progress never rolls in on wheels of inevitability. I believe that each of these nominees will be wheels of progress that bends the arc of our state and country's future towards justice. I proudly urge my colleagues to vote yes on each of these nominees.
Thank you, Senator Brown. Now, welcome Senator Portman for your introduction of the Ohio nominees. Please proceed.
Thank you, Madam Chair, and thank you to Chairman Durbin, Ranking Member Grassley, who was here at the outset. I'm appreciative of your allowing us to introduce these three distinguished Ohioans before the committee, and I appreciate their willingness to step forward at an important time to serve in these important new roles. Each of these nominees has pursued excellence throughout his and her legal career and dedicated much of their lives to public service. Each of them went through this bipartisan judicial commission process that Senator Brown mentioned, that we established to ensure that we have the very best candidates coming before this body. I support their nominations to serve on the U.S. District Court in the Northern District. David Ruiz is our first nominee. He has served as a magistrate judge for the Northern District of Ohio since 2016. He's a Buckeye through and through, undergraduate at Ohio State and a JD from The Ohio State University. And he has demonstrated his commitment to working for the people of Ohio in public service in many ways. Before his current role, he served as the Northern District's Assistant U.S. Attorney from 2010 to 2016, after 7 years as a senior attorney for Calfee, Halter, and Griswold in Cleveland, Ohio. I have every confidence he'll maintain the level of excellence he has demonstrated in his career in taking on this new role. Our second nominee is Bridget Brennan, currently serving, as Senator Brown said, as the acting U.S. Attorney for the Northern District. I have worked very closely with her in this role and in her previous role. She now leads a team of almost 200 working to represent the millions of Ohioans living in our 40 northernmost counties, including the cities of Cleveland, Akron, Toledo, and Youngstown. She's a graduate of John Carroll University and Case Western Reserve Law School. She has dedicated herself to serving the U.S. Attorney's Office for more than 14 years in a number of critical positions, including the office's first assistant, chief of the criminal division, chief of the civil rights unit, and the ethics advisor. Our final nominee is Charles Fleming, another alumnus of Case Western Law. For 3 decades, he has advocated on behalf of countless individuals as the assistant federal public defender for the Northern District of Ohio. He has also served in a number of other roles, including as the investigative and paralegal staff supervisor from 2010 to 2016 and the Cleveland trial team supervisor from 2016 to 2021. Charles's long record of service to the Northern District Court means he's well qualified to join the bench. I'm pleased to support these nominations before the committee, and I thank you for your consideration. As noted, the 3 district court nominees before us were recommended through this Ohio Bipartisan Judicial Commission. I want to acknowledge their hard work. They committed untold number of hours. It's not an easy job to ensure that we found well-qualified candidates to serve on the bench. I especially want to thank my representatives on the commission. I want to thank Senator Brown's as well, but I'm going to mention mine. All highly respected members of the bar in Ohio: Jonathan Adler, Julie Byrne, Elizabeth Callan, Art Hernandez, Pete Kirsten Now, Leah Pappas-Porner, Pete Patterson, Chris Walker, and Philip Williamson. I want to thank them for their service, time, and effort, as well as the other members of that commission, and we're going to be calling on them again. I was pleased to work with Senator Brown and members of our bipartisan commission to recommend these distinguished nominees to the president, and I'm glad they will have both of our support as we move forward. Thank you, Madam Chair.
Thank you, Senator Portman, and I commend both of you for relying on a bipartisan commission to provide us with these excellent nominees. And finally, we have Senator Murray here to introduce Judge Chun. Senator Murray.
Thank you very much, Chair Hirona. Chair Durbin, good to see you both here today. Thank you. It is my honor today to introduce Judge John Chun for a district court vacancy in the Western District of Washington. As this committee knows, Washington State had 6 vacancies open for a number of years, so I must begin by thanking President Biden and the Judiciary Committee for working so quickly to provide some long-awaited reinforcements to our bench in Seattle and Tacoma. In addition, I want to thank my nonpartisan Judicial Merit Selection Committee. It's comprised of 10 Washington State lawyers who so ably guided us in selecting the highly qualified nominees that have appeared before us this year, including Judge Chun. Let me share a little bit about Judge Chun. He has served for 7 years as a state court judge, both in his current role as a judge on the Washington State Court of Appeals and on the King County Superior Court before that. As we work to fill out the many vacancies in the Western District, Judge Chun's experience as a state court judge will add important experiential background to our federal bench. He will also bring experience as an attorney in private practice, where he focused on complex commercial and employment litigation, to his role on the bench. Judge Chun is a Pacific Northwest native, father, and the son of South Korean immigrants. He would be the first Asian American man to serve on Washington State's federal bench. He embodies a deep commitment to ensuring underserved communities have access to justice, having served as a board member for the Washington Low-Income Housing Alliance, an executive board member for the Asian Pacific Islander Community Leadership Foundation, and having taken on other pro bono commitments throughout his many years as an attorney and judge. Judge Chun is thoughtful, patient, and embodies vital qualities to being a good jurist. His commitment to serving as a district court judge reflects a responsibility to preserving our democracy through faithfully upholding the rule of law and treating litigants and parties before him with grace and respect. Judge Chun's qualifications are superb. His temperament and record of service demonstrate a real commitment to fairness and impartiality, and his service as a judge would surely help rebuild faith in our judicial system. I respectfully urge my colleagues to support Judge Chun's nomination. So thank you very much for allowing me to be here today.
I thank each of you for your coming forward like this. Before we turn to the nominees, so I know my colleagues are very busy, so thank you so much. Mahalo, as we say in Hawaii. And we'll set up for the nominees. Will our nominees step forward? Would you raise your right hands, please? Do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Please, have a seat. We'll start with Mr. Brennan. I'm sorry, Ms. Brennan. Can you proceed with your opening?
Good morning. Thank you. First, I would like to
Thank you. Good morning. First, I would like to thank Chair Durbin and Ranking Member Grassley for setting this hearing today. And thank you, Senator Hirono, for presiding today, and to all the members of the committee for considering my nomination. I would also like to express my sincere gratitude to President Biden for the honor of this nomination, and Senator Brown and his staff, along with Senator Portman and his staff, for recommending me to the President. I am also greatly appreciative of the comments they both made here this morning. Joining me today are my wonderful parents, Robert and Celie Ellen Meehan, who raised me to believe that anything could be possible if I was willing to work for it. Also with me today is my extraordinarily supportive husband, Terry, and our two children, Maeve and Tommy. I am so exceptionally proud to be their mom. Watching from home are my brothers, who are a lifelong support line for me. And I'd like to thank my many other family members, in-laws, and friends for their steadfast encouragement and support. And finally, I would like to thank my colleagues at the U.S. Attorney's Office, the defense attorneys in the Northern District of Ohio and its legal community, all of the judges in the district, and the courthouse staff. I have learned so much from all of them, and I hope to continue learning from them going forward. Thank you, and I look forward to answering your questions.
And in fact, if your family could wave so we know where you are, thank you. And for the other nominees' families and friends, feel free to wave when you are introduced. Judge Chun, please proceed with your opening.
Thank you and good morning. First, I'd like to thank Chairman Durbin, Ranking Member Grassley, and members of this committee and its staff for holding this hearing and considering our nominations. And thank you, Senator Hirono, for chairing this hearing. Next, I'd like to thank my home state senators, Senator Patty Murray and Senator Maria Cantwell, for recommending me for this nomination. And also, special thanks to Senator Murray for her very kind remarks just earlier. I'd like to thank the President for the tremendous honor of this nomination. And I'd like to thank the many family members, including members of the Chun and Baldwin families, friends, colleagues, including members of the Washington State Judiciary, and mentors who have supported me along the way. Finally, I'd like to introduce family members who are with me today. First, my parents, Peter and Helen Chun. They came to the U.S. from South Korea back in the 1960s. They worked incredibly hard to realize the American dream for our family. And today, I sit before you hoping to serve a nation that has given so much to our family. Next, my wife, Elizabeth Baldwin. She's my best friend, the love of my life, and I could not have made it here today without her. Finally, our children, Naomi and Hugo, who are missing school, music lessons, and sports practices to be here today, but they have been touring the Capitol this week and have been learning a lot from this experience. It is the honor of my life to be here today, and I welcome your questions.
Thank you, Judge Chun. And now, Mr. Fleming. Everybody, don't forget to turn on your mics.
Thank you, Chair Hirono, Chairman Durbin, Ranking Member Grassley, and all the members of this committee for having me here today. It's an honor and a privilege to be here. Thank you to Senators Brown and Portman for their kind comments this morning and for their recommendation for this nomination. And thank you, of course, to President Biden for having the faith in me, my background, and experience to nominate me for United States District Judge. I wouldn't be where I am today without my family, and I love them dearly. My mother, my sister Pat, my brother Reggie, and my niece Whitney could not be here today, but they are here with me in spirit and watching as we speak. My baby brother Carlos is here, and I greatly appreciate him flying in from Florida and taking time out of his busy schedule to be here to support his big brother. My very best friend in the world, retired Army Colonel Victor Tall, is here. Victor and I have been best friends since time immemorial, and I'm so glad that he was able to take time out of his schedule to be here. I'd like to thank the chief defender in my district, Steve Newman, and First Assistant Jacqueline Johnson, and all of my defender family for all of their support throughout the years and throughout this process. It is more appreciated than they will ever know. I'd like to thank my fraternity, Alpha Phi Alpha Fraternity Incorporated, for their support, kinship, and brotherhood throughout the years. I'd like to thank my better half, Miss Sarah Brown, for her love and support throughout this process. My mother, Norma E. Fleming, and my father, the late Judge Charles W. Fleming, were longtime public servants. They instilled in us certain core values: the value of hard work, treating people the way you want to be treated, honesty, integrity, and giving back to the community. And I hold those ideals close to this day. If I'm so fortunate to be confirmed, I look forward to continuing their legacy. Thank you.
Thank you, Mr. Fleming. And finally, Judge Ruiz.
Thank you and good morning. Thank you, Senator Hirono, for chairing today's hearing. Thank you, Chairman Durbin and Ranking Member Grassley, for scheduling this hearing and allowing me to be here today. I'd also like to thank Senators Brown and Senator Portman for the bipartisan support and humbling me with recommending me to the President. I'd also like to thank all the members of the Judiciary Committee, as well as all of their staff, for considering my nomination. I'd like to thank President Biden for having the confidence in me to recommend me to the Senate for this nomination. There are many friends, families, colleagues, and members of the bench in the Northern District of Ohio, as well as the court family, who are not able to be here today, as well as members from the Northern District of Ohio legal community who support me and whose well wishes have come with me from afar, and I know they're supporting me from afar. Unable to be here today is my sister, Deborah, who's watching with her family in South Carolina, as well as my grandparents, Lucas and Paula Ruiz, and John and Lenore Rangel, who are no longer with us, but I know who are watching with pride that their grandson sits here today before you. With me today are my parents, Augustine and Rebecca Ruiz, as well as my sister, Veronica, my amazing wife, Julie Fenstermaker, as well as my wonderful children, Gabriel, Lucas, and Isabella. My parents raised my sisters and I with the core value of respecting others, treating others the way that we want to be treated, with a strong belief in work ethic and hard work pays off, as well as a confidence to pursue our dreams. In pursuing one of those dreams, I was fortunate enough to meet my to-be wife, Julie, on the first day of law school. I've been blessed to have her part of my life ever since. With her unconditional love and her true partnership, I'm able to be here today. Senators, I appreciate the opportunity to be here. I'm truly humbled by this opportunity, and I look forward to answering all of your questions to the best of my ability. Thank you.
Thank you very much, Judge Ruiz. We'll start with questions from the senators here, and 5 minutes. We'll start with Chair Durbin.
Thank you very much, Senator Hirono. What a great panel. I've just been reading your backgrounds, staff before me, and their comments to me are very positive for each and every one of you. What an extraordinary experience you've had, and what more you will bring to the federal court. First, I'd like to ask Nominee Brennan. It was mentioned in your introduction by Senators Brown and Portman that you had been involved in a religious case that actually came to be the first instance where prosecutors used the Hate Crime Prevention Act to target religiously motivated violence. The wrinkle in that case is worth noting. This was not discrimination against Amish people by non-Amish people, but discrimination within the religion. Could you describe the situation to us?
Yes, Senator, thank you for that question. The particular set of facts in that case were one Amish community believed that others were Amish hypocrites, were not performing or recognizing the religion in the way that they should. and that community, referred to as the Bergholz community, set out through the leadership of one individual to enforce what they believed were religious practices on other Amish communities. And so what resulted were multiple violent attacks on individuals who were pulled from their homes or pulled from their beds and violently assaulted simply because of the way they chose to practice their religion.
This was Amish on Amish situations.
Correct, Senator.
As I read it, I thought that is unique. I'd never quite run into that circumstance. Mr. Ruiz, as a magistrate in the court, you have important responsibilities, but I am struck by the fact that most of us in Washington were paying pretty close attention to your work when you didn't even know it. And that, of course, relates to the opiate complex litigation, which was before the federal court, in which you participated in some aspects. Can you describe your involvement in that case?
Thank you for the question, Chairman Durbin. My role in the opiate multi-district litigation has been to assist Judge Polster in presiding over those proceedings. Early on in the litigation, Judge Polster established a litigation track in which he referred a number of bellwether cases to me to consider motions to dismiss that were filed by groups of defendants in the case, manufacturers, distributors, and so forth. During that time, I considered all of the motions that were filed, as well as the copious responses and filings in the case, and issued reports and recommendations to Judge Polster as to how I recommended he consider the motions to dismiss, as well as my recommendation to him as to how they should be ruled upon.
I'm going to try to describe what was going on in the courtroom. I'll probably miss it, and you can correct me, and feel free to. But this was civil litigation brought against the drug manufacturers when it came to opiates to determine their civil liability. And they were joined as a group in that court case. Is that pretty close to a description of what happened?
Yes, Senator. There are thousands of cases that were filed around the country that have been consolidated in the Northern District of Ohio to be handled as a group in multi-district litigation before Judge Polster.
What is the current situation or state of that lawsuit?
Many of the cases and groups of defendants have settled. There currently is a trial that Judge Polster was presiding over that was filed by 2 counties in the Northern District of Ohio against a group of pharmacies, and it's my understanding the jury is currently deliberating.
I'm sure everybody is anxious for that outcome. Mr. Fleming, President Biden has nominated a number of federal public defenders, and some of their critics have said they cannot be fair in a courtroom. They're going to judge people not guilty in case after case because of their background as defenders. What is your answer to that?
Thank you for the question, Senator. Senator, I was one of those kids on the playground that when I saw another child being bullied, I would intervene because of my desire not to see them treated unfairly. And it's that passion that motivated me to become an advocate. It's that passion that motivated me to become a public defender. And it's that passion that motivates me to become judge. And now, after 30 plus years as an advocate, I'd like to believe that I understand what it means to be fair and impartial in a particular proceeding. And I can say to the Senate and to you that if I'm so fortunate to be confirmed as U.S. District Judge, I will bring that passion for fairness and impartiality to the position of U.S. District Judge.
Thank you. Judge Chun, I'm sorry I don't have time. My time is concluded here, and we're on a roll call vote, which I'm in a race to do, and then try to return quickly if Senator Hirono needs me to give her a break at that time. But thank you very much as well for being here today. Thank you, Madam Chair.
Thank you, Mr. Chairman. I'll proceed with my questions and await the return of Ranking Member Grassley. I ask the following two initial questions of all nominees who appear before any of the committees on which I sit, so I will ask all of you these questions. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature? Please respond, each of you.
No, I have not.
No, Senator.
No.
No, Senator.
Have you ever faced discipline or entered into a settlement or related to this kind of conduct?
No, Senator, I have not.
No, Senator.
No, Senator.
No, Senator.
Thank you. So for all of the nominees, I'd like to highlight the range of professional experiences that we have on this panel. We have a prosecutor, a state court judge, a public defender, and a federal magistrate judge, and that is only each nominee's most recent job. Would you each tell us a bit about what you learned in your career that will be a particular asset as a district judge? We can start with you.
Thank you, Senator. Professional diversity, in my own personal experience, has been incredibly rewarding in the sense that I have been a plaintiff's civil attorney, a civil attorney on the defensive side, a criminal defense attorney, and most recently, for the last 14 years, as a federal prosecutor. Even in those 14 years, I have done both civil and criminal work. Having had the opportunity to view the judicial system from all those different perspectives and to represent clients with such varied backgrounds themselves, I think has given me an insight into the judicial process that would inform my ability as a judge, should I be confirmed, to ensure equal justice under the law. Thank you.
Judge Chun?
Thank you for the question, Senator. Before I was a judge, I served for over 18 years in private practice, litigating all sorts of civil cases in the complex commercial and employment areas. A substantial part of my practice was in federal court, so I bring that substantial litigation experience to the federal court position if I am so lucky as to be confirmed. In addition to that, I have had the great privilege and honor of serving on our state court bench, first as a trial judge and also as an appellate judge. As a trial court judge in the state court, I learned how to be a trial judge, and so I take that with me to the trial court position in federal court if I am so fortunate as to be confirmed. Also, as an appellate court judge, I've worked a lot on researching, analyzing legal issues, and writing opinions, and my understanding is that federal district court positions involve a lot of that type of work, so I bring that as well. Thank you.
Thank you, Mr. Fleming.
Thank you for the question, Senator. Senator, I've been a federal litigator now for 30-plus years. I started out in civil practice doing primarily employment discrimination and wrongful discharge type work, but a host of different issues during that practice. I then was offered a job with the Federal Defender's Office, where I've been now for the last just about 30 years and have had significant trial experience, I believe, the better part of 20 trials, quite a few appeals, and some briefing before the United States Supreme Court. I think in the totality of that experience, I have garnered quite a bit of knowledge with regard to issues that come up in federal court, the way to handle those issues, the idea of being fair-minded with regard to dealing with people and the issues before the court, and of course just the experience that goes along with being a trial attorney in federal court. And I'd like to believe that would benefit me and the court if I am so fortunate to be confirmed as U.S. District Judge. Thank you.
Judge Ruiz?
Thank you for the question, Senator. Over the course of a 21-year-plus legal career, I've had the opportunity to serve as a commercial and corporate litigator in private practice for a decade, serve as an assistant United States attorney handling both civil and criminal cases for 6 years, as well as for the last 4 years, I've had the honor and privilege of serving as a United States Magistrate Judge. During that time, I've had the opportunity to handle a vast variety of cases in both civil and criminal side. And the most important lessons that I've learned from the depth and breadth of my experience and the professional diversity that I bring are the core values of treating all persons with respect and dignity, of considering all parties' positions with an open mind, and working hard to assess the legal issues in the case to render correct decisions that are fair and impartial and dispassionate in every case. Thank you, Senator.
Thank you. Clearly, the diversity of professional experience that you all exemplify will stand you in good stead. Now, I'd like to call on Senator Hawley.
Thank you, Madam Chair. Thanks to all of the nominees for being here. Congratulations on your nominations. Mr. Fleming, if I could start with you, I want to ask you about the case of United States versus Brown, which was decided by the Sixth Circuit, in which you petitioned the Supreme Court to review. Do you remember that case? It's been a few years ago.
I do, Senator. Thank you.
This is a case, as I understand it, that involves a grandfather who used his two minor step-granddaughters as subjects in a child pornography film while he was their legal guardian. You represented him for several years. You made a number of arguments on his behalf that I want to ask you about, because I find them a little concerning. In 2006, you challenged the facial and as-applied constitutionality of 18 U.S.C. 2251B. That's the statute that deals with parents or guardians of children who are involved and complicit in the production of child pornography. You argued, and I'm going to quote now from the court's opinion, quote, that private production of a sexually explicit picture does not substantially affect interstate commerce, end quote, and therefore this statute should be struck down. Now, the District Court and the Court of Appeals both rejected that argument out of hand, and the Sixth Circuit drew an analogy between the production of child pornography and drug production, that both illegal goods feed the national market and stimulate demand. And at the time that he entered his plea agreement, the defendant whom you represented admitted to having uploaded this child pornography involving his granddaughters to the internet. So I just want to be clear here on your arguments. Do you still believe that the production of child pornography is outside of Congress's power to punish?
Thank you for the question, Senator, and pardon my hoarse voice. At that time, the arguments that we made on behalf, or I made on behalf of Mr. Brown, I did not intend to put forth the argument that Congress cannot, or that the statute cannot reach child pornography generally. What we were saying was that the statute, because they were applying the statute to Mr. Brown, and that arguably his conduct was intrastate, that the statute reached too broad for purposes of the Commerce Clause. Having said that, the Sixth Circuit ruled against me on that, and if I were so fortunate to be confirmed as United States District Judge, I'm duty-bound to follow the precedent of the Sixth Circuit, and I would follow that.
Why would it not affect interstate commerce when he uploaded the pornography to the internet?
There was no allegation. There was no allegation, as I understand it, and that's been the better part of 20 years since I litigated that case. Senator, so if I don't remember all the nuances, I apologize. But there was no allegation that, at least in the charges, as I recall, that he had distributed it. It was simply that he possessed those pictures. And so we were making the argument that, on his behalf, that that reached too far, since it was simply his intrastate putting on the internet, but not actually distributing the alleged pornography to others.
So is it your view that if a defendant merely, quote unquote, merely uploads child pornography, in this case involving his own granddaughters, to the internet, but doesn't actively distribute it in any other way, whatever that would mean, that federal law doesn't apply?
No, Senator. If I were so fortunate to be confirmed, I would follow whatever the precedent of the circuit and the Supreme Court is, at that time and apply it to the case before me fairly and impartially.
Let me ask you about drug laws, because the Sixth Circuit in this case specifically drew the analogy with our drug laws and said that this argument had been addressed in the drug context, that indeed the U.S. Supreme Court has repeatedly held that intrastate drug production of necessity affects the interstate market and therefore can be regulated. So let me just ask you whether you think Congress has the power to punish intrastate drug production.
Thank you, Senator. Not only do I understand the law to contemplate that Congress can regulate intrastate drug production, but Congress does regulate it. And it does so through 21 U.S.C. Section 841 and like statutes. And it does so through its Commerce Clause power, as you indicated, because it does affect the industry with regard to drug marketing. So yes, I believe that the statutory law and precedent supports the idea of regulating intrastate drug production.
Very good. I may have another question or two for you about this case, and that'll give you time. We'll give it to you for the record, which will give you time to refresh your memory. And I have a few questions for the other nominees as well, which we'll give to you for the record because my time's expired. Thank you all, and thank you, Madam Chair.
Ranking Member Grassley.
First of all, I apologize for the vote and for a phone conversation I had to have at a certain hour that I didn't hear your presentations. And like Senator Hawley, I'll probably have some questions to submit in writing when my time runs out. So I'm going to start with Judge Chun. In law school, you wrote an article praising the 1960s as a time, quote unquote, of revolutionary courts. You also said those courts drew from sense of social justice to establish strict liability and tort as a standard of defective products, end of quote. Will you follow that approach and draw from your sense of social justice if you're confirmed as to serve as a federal judge? And I hope you consider that a friendly question. I just want to know where you're coming from.
Thank you for the question, Ranking Member Grassley. I appreciate it. So the rest of that article, as I recall it, it's been a long time since I wrote it. The rest of that article, I believe, supports the risk utility test. And so it talks about the history of the development of product liability law back in the 1960s, and then talks about its development into the modern age. It supports the risk utility test. That's my recollection. I can assure you, Senator Grassley, that when I have a case before me, including a product liability case, I would apply the law to the specific facts of the case before me.
Okay, and then another question for you. You were trustee for the King County Bar Association in 2013. That year, this bar association proposed changes to the Washington Bar's rule of conduct. The proposal specifically created a safe harbor for cases where lawyers solely violate federal law. The change was prompted by a state law. That state law was on marijuana, but the proposal was much broader than just that. Three simple questions, I think they are. Did you support the proposed rule change? If you can't remember, I'll ask you to answer in writing.
I cannot recall. I was relatively new to that particular board, so it had already been being discussed when I joined it.
Okay. Since you didn't know, then maybe I ought to ask you to answer these other two questions in writing.
I'd be happy to do
But
so.
if you did, why should it be okay for an attorney to violate federal law? That'd be one. And third, why did you think it was acceptable for an attorney to advise a client? But if you can't remember, then I'll take your answer in writing.
Thank you.
Okay. Then for Mr. Fleming, maybe you've gotten so many questions you don't want another one. Anyway, you have had extensive experience working as a federal public defender. But as a federal district judge, you will need to handle both civil and criminal cases. If you're confirmed, how would you plan to get up to speed on civil cases?
Thank you for the question, Senator. First, I would note that my practice over these 30 years initiated as a civil practitioner. And at that time, when I was offered the job with the Federal Defender's Office, I had to make a very complex and relatively quick transition from the civil world to now understanding federal criminal law, federal mandatory minimum sentencing, and the U.S. sentencing guidelines as they were then. And as you know, in 1991, the guidelines were new and were mandatory. So I had a lot of learning to do in a relatively short period of time. I'd like to believe now, 30 years later, that I had some success with doing that. And I also am confident that if now called upon to transition back to a situation where I am now handling civil work or civil-related matters again, that I can make that transition easily and well. To further answer the question with regard to how I would do it, I would just note that I don't intend to be an island. I will have a staff that will assist me, clerks, law clerks who will assist me, and to the extent that my background may not be as extensive in civil as it is in criminal, I think it's going to be important for me to have law clerks who have a strong civil background so that we can balance out that knowledge and that skill set and be prepared to handle any of the matters that come before me if I'm so fortunate to be confirmed.
Okay, since I only have 6 seconds left, I'm going to submit to the other two nominees questions for response in writing. So I hope you'll answer them as soon as you can.
Turning to Senator Blumenthal.
Thank you. Thank you, Senator Hirono. I'd like to focus on an issue that's commonly raised for us, which is how your past experience informs what you will do on the bench. And I would like to ask each of the nominees to describe briefly what they think in their background is the most critical incident or experience, not just broadly, but specifically a life experience that will impact your decision-making on the bench. Ms. Brenner?
Thank you very much, Senator, for that question. So my background involves plaintiff side civil work on the defense side, representing individuals and corporations, criminal defense work, again, representing individuals and entities. And for the last 14 years, I've been a federal prosecutor in the U.S. Attorney's Office. But in that role, I have, while mostly doing criminal work, I have done civil work as well. And I think that that broad opportunity, or those broad opportunities to represent so many, has afforded me an opportunity to see the judicial system from so many different vantage points. I think a specific incident would be hard to capture. I think a role that I have played, an opportunity I've been given at the U.S. Attorney's Office could be most informing to you. For a number of years, I was the ethics advisor in our district. And in that role, I was asked often by colleagues to weigh in on what we should and shouldn't do in a neutral and dispassionate way. And in that role, I was very careful to assess what people wanted, what people hoped to achieve, but then to balance that and to give priority to what the rules were. And I think that that role would serve me well if I were to be confirmed. Thank you.
Judge?
Thank you so much for the question, Senator. I think for me, it does just come down to breadth of experience. When I was in private practice for over 18 years, I worked on a broad range of civil issues, complex commercial issues, and employment law issues. But the most significant experience, I would have to say, would be my experience as a judge. I've been a judge for over 7 years, a state trial court judge, as well as an appellate judge. And I'd bring with me to the federal court, if I am so fortunate as to be confirmed, a wealth of experience in trial judging. As a trial judge, I tried over or around 90 cases. I think over half of them were jury trials. And as a Court of Appeals judge, I've had a lot of experience researching, analyzing deeply legal issues and writing about them. And I've issued over hundreds of opinions. Thank you.
Thank you. Ms. Fleming?
Thank you for the question, Senator. My answer, I think, would just come generally from the nature of my experience. As an assistant federal defender for the last 30 years, the one thing that comes home to roost all the time is how important it is for people to feel as though the justice system is treating them fairly and that they are fairly represented and that they and their positions are respected. I think it's important for advocates to understand that, as I tried to do as an assistant federal defender, and I think it's important for courts and judges to understand that. And I think that's why judicial temperament and judicial disposition are so important. And I would bring that knowledge, if I'm so fortunate to be confirmed as U.S. District Judge. Thank you.
Thank you. Mr. Ruiz?
Thank you for the question, Senator. I think the best example of the judge that I would be fortunate enough to be confirmed follows from the lessons that I've learned over the past 5 years sitting as a city and magistrate judge in the Northern District of Ohio, which builds upon over 16 years of commercial and corporate litigation experience, as well as 6 years of experience as assistant United States attorney. And during my time serving as United States magistrate judge, I've worked hard to consider each party's positions with an open mind, to work hard to render fair and impartial determinations, to be well prepared in every case, because the role of a district court judge or a magistrate judge in federal court is extremely important. The judge directly touches the lives of all who come before the court, and to each litigant, the case that they have before the court is the most important case in the country to them. And it's important that the judge, as I have tried very hard to do over the last 5 years, reflect the seriousness and the importance of that case to all the litigants and all the parties. Thank you.
Thank you.
Thanks, Senator Blumenthal. Senator Blackburn.
Thank you, Mr. Chairman, and thank you all for coming before us. I represent Tennessee, and Tennesseans talk regularly about the importance of a fair judiciary, something that is equal treatment under the law. So having these hearings is important to us. Mr. Ruiz, I want to start with you. And very similar to what Senator Blumenthal was asking each of you, most of your background is in civil proceedings, and you have very limited experience in criminal proceedings, and you have not written significant opinions on federal or state constitutional issues in your role as a magistrate judge, even though you say you've learned quite a bit from that position. The majority of your writings and your decisions are unpublished. So could you tell us what in your judicial experience would give you the qualifications to sit as a district judge? And I'll give you about 30 seconds on that one.
Thank you for the question, Senator. During the past 5 years sitting as a magistrate judge, I had the opportunity to preside over extensive number of civil and criminal cases. During that time, as a magistrate judge, I'm responsible for approving and reviewing search warrants, pen traps, traces, criminal complaints, and other matters in the criminal world.
So you feel that the limited criminal and the civil work that you've had is a qualifier?
Thank you for the question, Senator. Not only the experience that I've had presiding over criminal cases and criminal hearings as a magistrate judge, I've also had the opportunity to prosecute a criminal case when I was in the United States Attorney's Office.
All right, let me end it with that because I want to go to Mr. Chun and talk with you about the amicus brief that the King County Bar Association submitted for Grutter versus Bollinger. The brief argued that promoting diversity in the legal profession is a compelling governmental interest, and that this compelling interest requires race-sensitive admissions. So I want to know if you still hold that view. And do you believe discrimination on the basis of race is permissible in college admissions?
Thank you for the question, Senator. I believe that brief was written almost 20 years ago, and I was on a team of lawyers that put that brief together. When I played that role in putting that brief together, I was serving in the role of an advocate, and our client was the King County Bar Association, and so I was trying to advance their position as best as I could.
Do you hold that view? And I would, if you want to submit this in writing, that's fine with me. But I would like to know if you hold that view, that a compelling interest requires race-sensitive admissions, and if that would apply to college admissions, and in what circumstances would you apply that criteria? And is it okay to discriminate on the basis of race in hiring? So we will send this to you so that you can give us a written follow-up, because I think it's important. If you were to be confirmed as a U.S. District Judge, you would take part in appointing the magistrate judges. And we would want to know if you would be using race as a basis for that criteria, if you would use it for law clerks. So let's get that to you in writing.
Okay, thank you.
Let's see, Mr. Fleming, do you believe that a 14-year-old can consent to sex with an adult?
Thank you for the question, Senator. I know that different states, like the state of Ohio, have an age of consent. And in the state of Ohio, the age of consent is 16. Okay. So I would be guided by the law and the precedent.
Well, let's talk specifically about U.S. versus Evans.
Okay.
You filed a sentencing memorandum in U.S. versus Evans for a defendant who was found guilty of cocaine possession and distribution. What you did was to move forward with this that had convictions. One of the convictions was corruption of a minor, which involved the statutory rape of a 14-year-old girl that resulted in the birth of the defendant's son. You argued that this rape should not be used as a predicate for career offender status because the victim had a son by the defendant and maintained a romantic and parental relationship with him. So I understand that as an attorney, you need to zealously represent your client, but I need to clarify your views for me. Do you believe that if a rapist impregnates his victim, it is no longer a crime of violence?
Senator, at that time, I was not espousing my particular belief. At that time, what I was asserting to the judge was that based on the state of the law and the state of the sentencing guidelines, that the court should consider the circumstances surrounding that conviction.
My time has expired,
Okay.
But I hope you understand that when an adult rapes a child and that child stays with her abuser, that is not a relationship. That is abuse, and that is called grooming. Thank you, Madam Chairman. I yield.
Thank you, Senator Blackburn. Senator Cruz.
Thank you, Mr. Chairman. Welcome to each of the nominees. Congratulations on your nominations. Mr. Fleming, let's start with you. You've had a number of questions today. I want to revisit the case of United States versus Brown. In that case, you represented a defendant who was charged with child pornography involving his two minor granddaughters. You argued that Congress did not mean to regulate child pornography when it outlawed producing visual depictions of minors engaging in sexually explicit conduct. The Supreme Court did not accept your argument. Explain that argument to this committee.
Thank you, Senator. And in doing so, I hope you'll allow me to clarify what I said earlier. There were two different aspects to Mr. Brown's case. One was there was child pornography or alleged child pornography that had been uploaded to the internet. And then there was alleged child pornography that he had produced, as you indicated, of his step-granddaughters. The child pornography alleged with regard to his step-granddaughters simply related to pictures that he took of his step-granddaughters, and the reason the government was prosecuting him for that was because he had taken them with items that had traveled in interstate commerce, like a camera, that was made by Toshiba or someone like that. And so what I was arguing as to the pornography alleged regarding his step-granddaughters, that because he simply took pictures and did not distribute that, it was simply intrastate conduct. We thought that created a constitutional question under the Commerce Clause as to whether it reached that intrastate conduct. We did not allege.
You also, after the Supreme Court didn't accept your petition, you then subsequently argued that the client did not produce, quote, lascivious visual depictions, even though the videos had pornographic content of the two granddaughters. Can you explain that?
Yes, thank you, Senator. Under precedent, when we talk about lascivious display of the genitals, precedent has indicated that's when the focus of the picture is on the genitalia, as opposed to just a general garden variety picture of a child who may not have clothes on. People often take pictures of children who are less than well dressed. The question was whether or not this was a lascivious display of the genitals, and we simply raised a factual question at the district court level for the court to decide whether or not this was, in fact, a lascivious display of the genitals, as opposed to just a picture of children who may not be dressed.
So I'm thankful I don't know the specifics of the facts of this case, but I suppose I'm obliged to ask, how graphic are we talking about? There's one thing if someone has pictures of some kids playing in a bathtub. There's something else entirely if they're engaged in or simulating sexual conduct.
Thank you, Senator. These pictures did not in any way engage in sexual conduct. As a matter of fact, funny you should mention, one of the pictures was them taking a picture of a kid playing in a bathtub. And so that is one of the reasons why we asked the judge to make a call at the trial level and sentencing level as to whether or not these are in fact lascivious. And we thought there was a...
What did the judge conclude?
The judge concluded that they were. But we thought because of the nature of the pictures and bathtub picture, like you indicated, that there was an open question as to whether or not they should be considered lascivious, and we wanted the Court of Appeals to weigh in.
Let me shift to Ms. Brennan.
Okay.
Ms. Brennan, you defended a law professor, Aisha Bell Hardaway, who was supposed to objectively evaluate whether the Cleveland Police Department complied with a consent decree concerning excessive force. While Professor Hardaway was on the monitoring team, she made statements disparaging police officers and suggesting that they were, quote, trigger happy. They were, quote, brutal in interactions with black people. She also said that it was, quote, disingenuously obtuse for people to, quote, profess that all police officers aren't that bad. Do you share the views of Professor Hardaway?
Thank you for the question, Senator. I do not take a position on another person's views. In that context, I think much more was being said. Ms. Hardaway was a representative of the court.
I'm sorry, I don't take a position on another person's views. Do you agree with what she said there? I'm asking what your views are.
I don't exactly remember the full statement that was made, so I can't put it all together. I know that was part of a longer segment on a radio show. But Your Honor, much conversation was had with the court about statements made by Ms. Hardaway. Her full context as a member of the monitoring team was assessed, and the judge and the monitor in charge of that monitorship determined that Ms. Hardaway should remain as a member of the team.
But she resigned after public outcry, and you expressed disappointment that she was no longer ostensibly, objectively evaluating the Cleveland Police Department. Is that right?
I guess I don't understand where that question's coming from, Senator. I don't remember what I said that was in defense of Ms. Hardaway.
You said that she was, quote, an integral part of the police reform process, and you expressed disappointment to lose someone of her caliber after she resigned following her condemnation of the police. Is that accurate?
I don't think that's a full quote. I don't remember saying anything about condemnation
No,
of police.
that's not in the quote.
Okay, thank you. Look, her viewpoints, her participation as a member of the monitoring team had been important, and the monitor believed they were important, and the judge believed they were important. And as a
Madam Chair, I would ask unanimous consent to enter into the record the formal statement from Acting U.S. Attorney Bridget Brennan, which reads, the importance of diversity in thought and experiences to the police reform process cannot be overstated. Professor Aisha Bell Hardaway was an integral part of this dialogue, bringing a unique combination of local knowledge and legal expertise. Her presence in the monitoring team facilitated the process and successes we have seen to date, and we were disappointed to learn of her resignation. Thank you.
Without objection. Before I close this hearing, I would like to note the many times that we have sat here listening to my Republican colleagues talking about how lawyers represent their clients, not necessarily sharing the views or the behavior of their clients. And so I have a lot of quotes here from to that effect from a number of my colleagues, and perhaps I'll enter these into the record. And I won't object to myself doing that. Thank you very much. Before I adjourn today's hearing, I note that the questions for the record will be due to the nominees by 5 p.m. on Wednesday, November 24th, and the record will likewise remain open until that time to submit letters and similar materials. We ask that the nominees work diligently to respond to those questions. Thank you to all of our nominees and to your families who have joined us and your friends. Congratulations once again. And with this, the hearing is adjourned.